Good afternoon to everyone. I now call the meeting to order at 2:07 p.m. Monday, April 4th, 2022 at the Bastrop Convention and Exhibit Center in Bastrop, Texas. I'd like to welcome Judge Fisher. I spoke to him a moment ago. Where are you, Judge? Hi, Judge. Are there any other public or elected officials here I'm not aware of? Okay, if not, we'll proceed. Thank you for coming, Judge Fisher. Item number 3, virtual and in-person public comments, limit 3 minutes each. I did not receive any non-agenda items. I did receive 2 requests to speak to item number 4. I just want to remind the board, since the hearing was closed, that they cannot consider anything they hear from these comments. But the public does have the right to speak them. So, Kermit Heaton.
This is just my personal opinions. I and millions of other Texans, through our representatives, established the Lower Colorado River Authority. And like any other governmental entity, they have special powers and authorities. But under the Texas and the U.S. Constitution, those powers are limited. Those powers were provided to the Lower Colorado River Authority to conserve surface waters in the Lower Colorado River drainage areas, not to be a groundwater developer. I want to thank all of you for your often thankless efforts, but thank you. Thank you very much.
Thank you, sir. Mr. Heaton.
Hello, I'm Hugh Brown. I'm a landowner in Lee County with wells in both Calvert Bluff and Simsboro aquifer. I would like to say that I would like for the LCRA, whatever level the board chooses to grant them, 0, but more than that, that they would require LCRA to do recharge augmentation to a quantity equal to what they plan to pump, because I think we're already pumping too much. Now, having said that, I would also like to say that we all know about Houston toad being an endangered species. There is another species of concern, and it's not part of the threatened list, but it's on the watch list. It's called a western lesser siren. It's about 1 foot long, about as big around as your finger, and black. It's an amphibian. It's kind of salamander. It's got 2 little front legs, no back legs, external gills. Lives its whole time in water. If the water dries up, it buries in the mud, but it can't, of course, live that way forever. So that is an animal that is completely dependent on water. And that means if we lose springs or other flow, then that's going to hurt that animal. And it's already, people are already watching it. So I wanted you to be aware of that. Thank you very much.
Thank you, Mr. Brown. Mr. Totten, do we have any online in the chat room?
At this point, the only time that we received.
Okay. Are there any other comments from the public? If not, we will proceed to agenda item number 4. Rehearing on the district's decision on the applications of Lower Colorado River Authority for operating permits and transfer permits for 8 wells in Bastrop County. SOA docket 952-919-0705. I also want to mention that we have 3 board members that are recused from this. Mr. Phil Cook, Mr. Elvis Hernandez, and Ms. Kay Rogers. I would first like to call the applicant from LCRA, Ms. Rogers. And I understand you have 20 minutes, but if you don't use them, you can reserve them till the end.
Okay, very good. Thank you. Good afternoon, ladies and gentlemen. My name is Emily Rogers, and I represent the Lower Colorado River Authority. LCRA requests that this board grant LCRA's applications and issue the operating permits for 25,000 acre feet of groundwater to be developed in phases as recommended by the ALJs, except for the required surface water monitoring. The judges, who are neutral hearing officers, evaluated the credibility of each witness in person, weighed the controverting evidence, and ultimately concluded that LCRA had met its burden of proof and should be issued the required permits. Contrary to the arguments you will hear from the protestants, your options for changing the ALJ's rulings are very limited under Texas law. Texas Water Code Section 36.4135, which is displayed on this board over here to your left, only allows specific types of changes. Specifically, you can change the ALJ's proposed findings and conclusions only if you determine one of the following 3 things have occurred. The ALJs did not properly apply or interpret the applicable law, district rules, written policies, or administrative decisions. A prior administrative decision on which the ALJs relied is incorrect or should be changed, or a technical error in the findings of fact should be changed. Chapter 36 was changed in 2011 and amended in 2015 to allow for the referral of these permitting cases to SOA judges. This was done specifically to ensure that the contested evidence in groundwater permitting hearings would be considered by neutral judges and are not susceptible to local politics or strong emotions. And the specific language within section 36.4165 that limits what the boards can change in an ALJ's proposed finding and conclusions achieves that goal by preserving the role of the ALJ as the fact finder and the one who weighs the evidence and evaluates the witness's credibility. In other words, as much as you want to reweigh the disputed evidence, delete inconvenient findings in this case, and reach a conclusion that's different than the ALJ's, you simply can't. The word only in that phrase on that board means something. It's mandatory, not permissive. Here, the ALJs did exactly what they were charged to do. Recharge's no evidence mantra, which other protestants have apparently adopted, is completely unsupported. Attachment 2 to LCRA's latest brief provides a summary of LCRA's evidence presented to the ALJs regarding the effects of pumping on the groundwater and surface water resources, including analysis of Recharge's yet to be constructed wells, Aqua and Elgin's wells, and the Brown landowner wells. This evidence included more than just GAM runs, as other parties would like you to believe. The ALJs did their job, weighed LCRA's evidence and credibility of its witnesses against the arguments and evidence proffered by the protesting parties. They determined LCRA's evidence and witnesses were more credible. And based on that, the ALJs determined that LCRA's proposed pumping would not unreasonably affect existing groundwater users, and the conditions and limitations in the permits minimize drawdown and lessen well interference. The fact that the PFD did not detail every piece of evidence submitted at the hearing does not mean the ALJs did not consider it, and the law doesn't require that. When this board adopted its order in November 8th, 2021, it made sweeping changes to the proposed findings and conclusions that are reflected in attachment 1. These changes included deleting some findings and conclusions in their entirety. Yet you provided no explanation, written or oral, for ignoring or altering the ALJ's findings and conclusions to reduce LCRA's authorized pumping from 25,000 acre feet to 8,000 acre feet. You act as a board. And the only way you can do that is act collectively and provide those required explanations in a motion or through some written order. The other parties suggest you don't have to somehow justify these changes. Well, they're just flat wrong. It would make a mockery of this entire process because a groundwater district could simply just strike all of the ALJ's evidentiary findings without basis and then deny the permit for lack of evidence. While simply rejecting the ALJ's findings without explanation may be appealing to you, it's just not the law. Not only does 36.4165 require you to make that determination, but failing to provide the reasons for the change to the ALJ's recommendations is contrary to section 36.4165. The lack of explanation in the record denies a reviewing court any ability for meaningful judicial review of your decision and is arbitrary and capricious on its face. And if not corrected, will result in your order being reversed by the court on appeal. Even your general manager recommends in abundance of caution that you provide explanations for your changes. As mentioned earlier, LCRA is also continuing to ask this board to remove the requirement for surface water monitoring in the permits. The board did not remove these requirements in its November order. The district has no authority to impose requirements as it has adopted no rules or standards for such requirements. Further, it is applying this requirement only to LCRA, even though contrary to environmental stewardship's repeated claims, the district's own order incorporates the ALJ's determination that LCRA's pumping alone will not cause unreasonable effects to surface water. Worse yet, even if the district had the authority to impose monitoring requirements in the first place, they would be inappropriate here because there is no reasonable proportional nexus between the surface water monitoring requirement and the regulation of LCRA's pumping. The US and Texas Supreme Courts have made it clear that conditions that don't have a nexus are unconstitutional. Aside from surface water monitoring, LCRA's motion for rehearing also identified various provisions that the board's November order included in the approved permits that are contrary to controlling law, particularly in the context of permits for 8,000 acre feet. In essence, the law doesn't allow you to impose requirements on a transporter that are more restrictive than you impose on your in-district permittees. Moreover, if you are going to put additional restrictions on LCRA as a new permittee, you have to be ready to impose those conditions on subsequent permits. The district isn't doing this, but instead is imposing restrictions only on LCRA without providing legal justification. The board now has an opportunity to correct the mistakes it made in its November 2021 order. The board should allow the ALJ's recommendations regarding the issue of the permits for 25,000 acre feet of water per year, with the exception of the surface water monitoring. The ALJ fact finders made their recommendations based on their assessment of the evidence and witness credibility. To reach a different conclusion will result in this board reweighing the evidence in contravention to Texas Water Code 36.4165. Thank you. I will reserve the rest of my time.
Certainly. Thank you, Ms. Rogers.
Just a couple quick questions.
I'm
Okay.
sorry, what?
Can you take a couple quick questions?
Sure.
First off, I think you mentioned in the brief that the deletions that we put in there, the deletions were impermissible. So you don't think that we have the right to delete findings or conclusions that are not relevant to the permit?
Not without providing an explanation.
Okay,
A deletion is a change to the order.
I understand. Where do you think that says we have to provide an explanation?
It says, how else are you going to comply with this if you don't provide the explanation to the public? In fact, case law is clear on this point. Doesn't say, you're right, it doesn't say it has to be in writing, but you have to give the parties fair notice of what it is and the courts. And if you delete a finding, that's changing it.
Does it surprise you that the words in writing occurs 10 different times in chapter 36?
It doesn't surprise me, but how else is the court going to know unless this board has a motion, an oral motion that goes through and explains why it's making the changes? How else is a court going to be able to review that?
Okay, so this is all about notice more than providing a written explanation.
I would say it's about notice, but your best way to do that is providing it in writing. That is a long PFD. And those were a lot of changes. And if you go look at what they do under the APA, which I think this was modeled after, in fact, I know it was modeled after that. You go look at what they do at other state agencies, they go through line by line and tell you why they've made that change. So your overall change was to go from 25 to 8,000 acre feet. You need to explain that.
3605, I'm sorry, 2001-058 also says in writing.
I'm not disputing that it does. I'm not disputing that.
Okay.
However, you have provided no explanation.
Okay.
Oral or otherwise.
You're asking us to remove the surface water requirement?
Correct.
So you think that those changes to the BFD are justified?
Yes, I think you can justify that. I think you would need to tell why you're removing it. And I think we've explained the very legal reasons for you removing it. Constitutionally, you're asking LCRA to go put in surface water monitoring, but you have linked that monitoring to nothing in LCRA's permit. You're not going to go reduce their pumping. If something happens, you don't even know what you're monitoring for.
Okay. And does that, because you're making a legal argument here about,
Correct.
I assume as a conclusion of law that we can't apply that surface water monitoring requirement to LCRA, does that mean that we can or cannot change the findings of fact related to surface water?
If you have a justification, you can change the finding. You can say this finding of fact was incorrect, probably to the ultimate finding of fact. Now, if they say LCRA, like they did in the PFD, LCRA will not cause an unreasonable impact to surface water. That's probably one you don't change because they're the one that weighed the evidence. But when they came to their conclusion that you can impose surface water monitoring, when you've adopted no rules about it, we don't even know what it's going to look like. And there's no link to LCRA's pumping to what happens with the monitoring. There's no link between the two. I think that's a legal reason that you can use to justify deleting that provision.
Okay, thank you.
You're welcome.
Board members, did y'all have any further questions of Ms. Rogers? Okay, if not, we'll proceed. Next, Aqua, City of Elgin, Mr. Gershon, Mr. Ruiz.
Good afternoon. My name is Cole Ruiz. I'm here on behalf of the City of Elgin. As you all know, the City of Elgin is a party to this case because it's got 4 wells that would be unreasonably impacted if LCRA were to be granted what it's seeking. I'm not going to spend a whole lot of time talking to you about the merits of what we're here to talk to you about today. I think it's been said, the record shows that. But I wanted to appear here before you as Elgin is an interested party. I'll say that so far, I think you as a board under good counsel have done a great job. And we hope that whatever comes out of this is substantively similar to what's already been proposed. And I'll stand for any questions if you have any.
Board members, any questions?
Thank you.
Thank you, sir. Mr. Gershon?
Yeah, Mike Gershon with the law firm of Lloyd Gosselink. I represent Aqua Water Supply Corporation. As you know, Aqua has protested LCRA's permit applications and throughout the proceeding has taken the position that 8,000 acre feet of production per year is the right number. Aqua appreciates that this board has made a decision on this application to grant 8,000. We think that that's the correct decision. As with Mr. Ruiz said, he is not going to get into the merits. There is quite a mountain of evidence that the administrative law judges had to get through to make a recommendation to you. There are a number of different perspectives as to whether the application should have been denied or granted in some part. Aqua also took the position that the LCRA application could be denied in its entirety because LCRA did not meet its burden, and we're not here today to talk about that. Today, we are here focused on the motion for rehearing, which criticizes essentially the manner in which you all have reduced to writing your decision. Aqua believes that Mr. Ellis, in the last exchange with LCRA's counsel just a few minutes ago, has it right. He's distinguishing between the Administrative Procedures Act in the Government Code and the Water Code. We believe Mr. Ellis is correct in his assessment of what's required in what you reduce to writing and what you communicate to the parties. And so we stand behind what the board's decision has been, and we look forward to supporting the district and its board as we take next steps procedurally. So Aqua continues to maintain the position that the decision made was correct. And we have confidence that you are in good hands with legal counsel to the extent some relatively minor attention to that decision may be taken care of. Thank you.
Questions?
First off, I appreciate the comments. I'll be quoting you when you have your clients in front of my clients at some point in the future, I promise. I think one of the key issues here is that, we need to do everything that we can to make sure we're following the statute, following the rules. And the ALJs proposed a permit that included multiple phases. We have done that 2 other times in other permits, and you participated on behalf of a client contesting one of those permits and did not object at that point to that phased in approach. You had reached a settlement with the applicant and did not object. Do you find anything, is there anything in chapter 36 of the district rules that would allow a phased in approach?
Not in the manner that LCRA has requested it. This board has granted phased permits before. Those are distinguishable because those matters were settled. They were settled after hotly contested proceedings. Section 36.113, I believe, is the statute that addresses permit conditions. And I believe it's clear when you can impose a condition versus accept a condition that has been voluntarily agreed to by the applicant and the protestants and the district, of course. I think that what you did to allow phased permits in the past is distinguishable because those cases were settled. LCRA chose not to and did not have any interest in discussing settlement. What that they've asked for in terms of phasing is something that our client is not comfortable with. It proposes to kick the can down the road in evaluating what impacts would be through subsequent phases in a manner that we don't think is consistent with Texas law, that deprives our clients' rights. Back to your question about whether phasing is allowed in anywhere in Chapter 36 of the Water Code. I don't believe the term phase or phasing or any derivative therefore is in the chapter. Certainly 36.113 allows you to impose conditions. The statute is not, well, I believe it is clear about how you handle settlements. I don't think your hands are tied in the way you go about structuring conditions when you're settling, as opposed to a situation that the applicant has not agreed to.
Well, and more importantly, the Water Code, Chapter 36 limits those who can appeal a decision of this board on a permit to those parties that participated in the contested case hearing on that permit, right?
Yes.
So if all the parties have agreed to these conditions, I don't think anyone else has standing to file an appeal of that decision, right? You think a third party could come in and argue that the recharge or the gatehouse phased in approach was improper and the board shouldn't have done it?
Of course. I mean, Mr. Ellis, you're right.
So, I mean, that, to me, that's a critical difference. Do you have any objections to the version of the permit that the general manager attached to their brief?
We have no objections to the, and really Aqua's focus has been on the annual authorization. And we understand that permit to propose no more than 8,000 acre feet to be produced. Beyond that, we have no objections.
And I'm sorry, I skipped over something there. Back to the phased in approach and imposing that over the objection of some of the parties. The purpose of that, and again, calling back on your participation in the recharge project of the permit that's issued. Isn't it the case that when you have when you have a permit, it's automatically renewed at the same numbers unless an amendment is requested, correct?
At the end of the term, that's correct. There's a provision
Okay.
that provides for that in the statute.
The statute allows a district to adopt rules that require an amendment process if there's a substantive change to that, the terms or conditions of the permit. And this district's rules specifically require an amendment if you're going to change or increase the amount of pumping. So do you see this phased in approach they've approved in the past as being a workaround around that amendment process? In other words, is it possible using a phased in approach, the district can avoid having to go through the amendment process, or that, I'm sorry, not the district, but the applicant permittee could avoid having to go through that amendment process if they have a phased in approach?
I understand the question. And but let me say it this way. Does a permit that provides for phasing get automatically renewed if the permit holder meets each of the three terms in the statute? Yes, of course. Depends on the unique factual circumstances of what's being phased and the ultimate quantity. I mean, Aqua has been clear throughout that more than 8,000 acre feet is a problem for a variety of reasons that we're not here to discuss today. It wouldn't be appropriate to dig in on the merits. But if we're comparing the LCRA case to what happened with recharge and NDOT, very different circumstance.
So you don't think those prior decisions, those prior permits ties this board's hands on what we do in the future?
I do not. I believe that the way that the board handled the permit conditions with recharge is different from what you're dealing with LCRA. Procedurally, it's different. There was resolution by all of the parties involved in the case. The general manager, Aqua, were on board with the approach that was taken. There was also significant mitigation required. The nature of the wells and the nature of the impacts, again, same aquifer, different factual circumstance.
Okay, thank you.
Board members, do you have any further questions? Thank you, sir. Recharge, Mr. Carroll or Mr. Reese? Oh, I'm sorry, Mr. Rutherford.
Good afternoon, members of the board. My name's Shan Rutherford, and I'm here on behalf of recharge water, a protestant. Just want to address. Yes, sir. Just want to address two of the points of error. And the first one is what you've been talking about, point of error number one. And the essential argument there is that the board of directors did something wrong, that its decision to grant only 8,000 acre feet was a second guessing or reweighing of the ALJ's consideration of the evidence. I think that's false. Recharge believes that's false. We believe that the judge, that the district's final order was basically determining that the ALJs failed to apply and interpret the Texas Water Code legal permitting requirements and the district's permitting rules. I think that your attorney will be able to explain that in LCRA's reply briefing, none of those cases that were cited or referenced to apply to a groundwater district permitting decision under Chapter 36 of the Texas Water Code. There are distinct differences between the Administrative Procedure Act and Chapter 36. And I think you can assume that those differences were made for a reason. Secondly, the main issue that we want to address is point of error number 3. And this is the board's decision to limit the authorized production to 8,000 acre feet per year. LCRA claims that this board engaged in an improper weighing of the evidence. Again, this board determined that the ALJs failed to apply and interpret the Texas Water Code legal permitting requirements and this district's permitting rules. LCRA's reply briefing further proves that there was no evidence supporting the production of 25,000 acre feet from a small strip of the Griffith League Ranch property. Because first LCRA in briefing attempts to defend the ALJs by arguing without citation that a proposal for decision is not required to present a neutral, detailed reflection of the evidence. That's not what happened here. Had I been in LCRA's position in briefing this, I would have pointed out every place where the PFD so much as mentioned the evidence that supported LCRA's requested 25,000 acre feet of production. Secondly, I would have pointed out in briefing all of the steps LCRA took to minimize impacts to existing landowners, which is a legal permitting requirement under Chapter 36 of the Texas Water Code and under the district's rules. LCRA didn't do this. Instead, LCRA is arguing that the board, and I'm quoting, the board cannot ignore the ALJ's evidentiary findings. But Recharge would submit that that's the problem. There were no evidentiary findings in the PFD on this issue other than a passing reference to satisfying the district's minimum spacing rules and noting that the district can resort to an after the fact cutback. Finally, LCRA resorts in briefing to a warning that this board is about to set a quote unquote dangerous precedent if it finds, as a matter of law, that the groundwater availability model alone is not sufficient to determine unreasonable impacts. What LCRA is arguing here is that the GAM alone, a regional model covering an enormous area, even if shown to be wrong for the actual site of proposed drilling, should be enough. And if it isn't, that the board should require site-specific analysis for every small permit that comes before the board. LCRA points specifically to the pending Bastrop application and to other previous permits as examples of this dangerous precedent. Bastrop, unlike LCRA, has already engaged in pre-application site-specific testing through its original application. Bastrop, unlike LCRA, has already agreed to mitigate any harm to neighboring landowners resulting from its pumping. Bastrop has applied for a small fraction of what LCRA applied for in this case of production levels. Recharge, unlike LCRA, engaged in site-specific testing, conducting a many weeks-long pump test. Recharge, unlike LCRA, designed its well field to minimize impacts by spreading it out over many miles. Recharge has already agreed, as Mr. Gershon pointed out, to mitigate any harm to neighboring landowners and utilities. In short, this board would not be setting any precedent, but would instead be upholding precedent by recognizing LCRA's failure to meet its burden of proof on minimizing impacts on neighboring landowners and utilities. Thank you.
Board, do the board members have questions for Mr. Rutherford?
Real quickly, do you have any issue with the general manager's proposed permit in their latest brief? Did you get a chance to look at that attachment to their brief?
I would rather not take a position on some of the specific issues. We've chosen as a legal matter not to contest certain issues with which we may, or I may personally disagree. But we're going to leave that to you all.
Okay. All right. Thank you.
Thank you.
Thank you, sir. Mr. Grisham for the Brown parties.
Thank you, members of the board. As I'm Don Grissom, and I represent the group known as the Brown landowners, who are protestants in this, individual landowners and well owners in this district. And we agree with what's come before. We support the permit that you had issued. We hope that it stays in substantially that form. We would like to address their motion for rehearing, particularly point of error number 3 with regard to the 8,000 square feet. They, there's under your rule 5.2D8, we think there's more than one interpretation there. We think that the parties did publicly discuss the major elements of the permit, that the LCRA anticipated receiving a lesser amount, and also that the Brown landowners demonstrated unreasonable effects on their water wells that meet the correct criteria. Now, as we went through this, as regards their comments to the rule 5.2.8, the ALJ's comment on this was that the districts and the GM approach to and their method of looking at the conditions under 5.2.D appeared appropriate. They did not go into any particular analysis as to how you are to treat those. They just said that the way that the GM looked at it appeared appropriate, which gives you wide latitude in making that decision. LCRA wants to take all discretion away from you. We believe that rule and the way the ALJ presented that, it gives you wide discretion on that. So you're not handcuffed to those particular comments. The 8,000 acre feet is appropriate in keeping with the district decision regarding the DFC and the Simsboro. We believe that strongly. And that the additions of your findings of fact 38 through 41 demonstrate that the board understands its statutory responsibilities under this rule. Now, contrary to what LCRA has contended, 8,000 acre feet and the monitoring well agreements were discussed here January 28th, 2021. The issue with waste or wasting, 36-hour pump tests were discussed here openly on July 14th. So all of those issues have been well versed. We think that the board has acted appropriately in discussing all of these issues and hearing us and hearing all of the different points of view. And we think that your decisions so far have been inappropriate also. When you look back on this, the evidence at the hearing, the uncontroverted evidence at the hearing was that LCRA anticipated all along that you would award less than what they were asking for. Particularly this came from two sources. One, Mr. Andy Weir. Two, some of the documents from LCRA's own experts, their emails, which talked about how they were going to approach the board and the district in their application. And they ran, and we showed these before, all of these different charts. What does it look like if we do this? If we ask for 15, what does it look like if we ask for 10? What does it look like if we ask for 15? They don't have the answers to that. They don't have the scientific evidence of what it looks like, other than as it goes up, the conditions get worse. So the email chain, which was introduced and Mr. Weir testified, again, unchallenged, uncontroverted. No one came back and say, no, that's not true. Their own email showed, well, why don't we ask for 25? Because when we look at what everybody else has asked for, what did they get? Well, in this case, it's all in their emails, they got 62% of what they asked for. Well, what about this case over here? Well, they got 80% of what they asked for. Okay, let's ask for 25. Knowing full well they were not going to get the 25. Knowing full well they had no basis for asking for 25. Knowing full well they had no evidence to support 25. And so they can't come here saying, we put on this great case, we're justified in getting 25,000 phased in. It doesn't hold water. This district saw through that. You ruled appropriately, or you acted appropriately in granting a permit of only 8,000. While we, the Brown landowners, probably more in line with the recharges, they didn't meet their burden, and they didn't. But that's not what we're here for today. If you're going to give a permit, we certainly recommend that it be substantially in line with what you've done. Like I say, all of this testimony was unchallenged throughout. Now they spent a lot of time on their unreasonable effects. And this is where I think you have grasped it. And that is, there was no evidence. We're talking zero evidence by LCRA about unreasonable effects. They did not want to address the subject, and they did not. The extent of that was when they did their application, we ran the GAM, which we all know is a regional tool only. You're required to look at local impacts. They did not. All of the evidence that came out from Aqua, Elgin, Recharge, Brown landowners, all of them, when they started drilling down, well, what about this? What if you reduce the ability to produce water? And this was, propounded to their expert, Mr. Young. What if we reduce the ability to produce water? Is that an unreasonable impact? Well, yeah, that would be. Well, what if it required substantial expense to repair wells for which? Well, yeah, that would be too. Well, what if we degrade the quality of the water? Would that be an unreasonable impact? Well, yes, that would be too. So from his own testimony, he says, yes, those are unreasonable impacts. So if there's a drawdown at Calvert Bluff to the extent that they couldn't use their well, that would be an unreasonable impact as well. His answer, their expert, according to, it would be unreasonable. In fact, based on the criteria I set forth, that would apply to all oil wells, not just the ones in Simsboro. His own testimony, unreasonable. So there is an unreasonable impact. They have no evidence to the contrary on that point. And like I say, they didn't even put any on. So for those reasons, Mr. Rice, who is one of our experts, took the facts and put the facts up there. Again, these facts are unchallenged. They were never controverted by LCRA, not even questioned whether or not they were right. 20% of the landowner's wells will require some type of mitigation or need to be replaced. That, Mr. Young said, was unreasonable. 28% of the Brown landowners may suffer degradation of their water quality. Again, Mr. Young, their own expert, says that's an unreasonable impact. All of this was omitted from the ALJ's report. Again, we come back, there was no evidence of any other.
Excuse me, you have 30 seconds, sir.
Thank you. Well, with that, I will wind it up and see if you have any questions. But we thank you for your time. We support what the board is doing. We understand you have a difficult decision to make. And we'll be ready to answer any questions you have.
Thank you, sir. Board members, do you have questions? Commissioner Grissom?
Well, the slide went away. Does the board have the authority to add the findings of fact that, for example, the items that you have from Dr. Rice at this point, or can we only look to the findings of fact as presented by the ALJs?
I think the record is overwhelmingly obvious that there was no evidence on these points.
Well, no evidence different than adding brand new findings of
Right.
fact.
And I think that you have the power to do that.
Okay,
Thank you.
thank you.
Thank you, sir. Environmental stewardship, Ms. Perales.
Good afternoon, Chair Smith, Mr. Ellis, board members. My name is Marisa Perales, and I'm with the law firm of Perales, Allman and Ice, and I'm here on behalf of Environmental Stewardship. I'd like to start out by pointing out how LCRA, in its reply to the responses to its motion for rehearing, has maintained that it is the steward of the Colorado River, and it is committed to protecting this resource. Yet, it has consistently failed to acknowledge what the evidence in the record demonstrates, and that is that the GAM model, the best available science, the model that was relied upon by LCRA, the general manager, and environmental stewardship, predicts that there will be impacts to the surface water system as a result of the proposed LCRA pumping. According to Dr. Hutchison, who testified on behalf of the general manager, it's unreasonable to summarily dismiss the potential for an impact on surface water resources. LCRA bore the burden of proof in this proceeding as it was the applicant. And that means that it bore the burden of proof of demonstrating compliance with Water Code 36.113D2, which requires consideration of whether the proposed use of water unreasonably affects existing surface groundwater and surface water resources or existing permit holders. Whether this requirement is constitutional or not is not for this board to decide. That is an issue that can be taken up with a court with jurisdiction to decide the constitutionality of specific statutes. But that is the directive that the legislature has imposed upon this board. And here, the evidence demonstrates qualitatively that there will be an impact on surface water resources. The evidence demonstrated that it would be unreasonable to dismiss the potential for impacts on surface water resources. In other words, LCRA did not satisfy its burden of demonstrating compliance with Water Code Section 36.113 D2. So a requirement that any production permit issued to LCRA include monitoring of impacts to surface water resources is eminently reasonable, and it is within this board's discretion, particularly in this case, based on these facts, where LCRA simply failed to demonstrate that its proposed pumping wouldn't impact surface water. The board, as I mentioned, has been charged by the legislature with ensuring protection of those surface water resources of the Colorado River from any unreasonable impacts. And a surface water monitoring requirement would implement the board's responsibility in this regard. If the board elects to delete the requirement that a monitoring well agreement be implemented as part of LCRA's production permit, it should nevertheless maintain a surface water monitoring requirement. As to the specific language for that surface water monitoring requirement, that too is within the board's discretion. But the special condition number 1 that was included in the permit that was issued by the board, that would serve as a good model language for surface water monitoring requirement. And I would implore the board to use similar language to ensure that surface water monitoring is included with any production permit. And as to the argument as to linking this surface water monitoring requirement, the link is to determine whether there are any unreasonable impacts that have occurred as a result of the LCRA pumping. I mean, the evidence failed to show that there would be no impacts. And so implementing a surface water monitoring requirement would develop the information, the data that's necessary to determine whether we are seeing impacts on surface water. And I would remind you that implementing this surface water monitoring requirement would not require any deviation, any change to the ALJ's recommendation. Thank you for your consideration of this application, and I'm here to answer any questions.
Board members, questions? Mr. Ellis?
The statute says that we have to consider whether the proposed use of water unreasonably affects existing groundwater and surface water resources or existing permit holders. And the applicant has the burden to prove what? They have to prove the negative, that there will not be an impact?
That's right. I believe that in order to demonstrate compliance with that particular requirement, they would have to show that there would be no impact. And in fact, that's what they attempted to do with the testimony of their expert witness. But it did show, the GAM model did show that there would be expected impacts on surface water resources, at least qualitatively.
Is the board prohibited from issuing a permit that will cause unreasonable impact?
Yes.
But even though it says the district shall consider, you think that that is a prohibition, we can't allow that to happen?
I believe that if the board is directed to consider whether a permit, a groundwater permit, would have unreasonable impacts on surface water, that means the board is intended to do something about it, to ensure that there aren't unreasonable impacts on surface water.
Kind of the same question I had for Don. The ALJs put forth a set of findings of fact. We can remove findings, I believe, that are irrelevant or don't follow the law or have no evidence to support them. Do we have the ability to go into the record and add new findings of fact?
Let me start my response by saying I don't think you need to for the purposes of the surface water monitoring requirement, because the ALJs recommended it. Yes, I mean, we've seen agencies change findings of fact before so long as it's done within the parameters of the directives that the legislature has imposed on the groundwater district, including some sort of explanation as to why the changes are being made.
We all know that statutes provide an outline, if you will, some bookends, things we have to do, things we can't do. The rules are there to flesh that out, to provide some additional guidance and certainty to what is supposed to happen. Is there anything at all in West Pines rules that deal with surface water monitoring?
The rules pretty much mimic the Texas Water Code's statutory directive with regard to considering unreasonable impacts on surface water resources, as I recall. I don't recall seeing anything specific in the rules that states that permits may or should include surface water monitoring requirements.
But there are specific requirements on groundwater monitoring.
That's right.
I assume you can say yes, but is there anything in the general manager's proposed permit that they included in their brief that you object to?
So the draft that was included with the general manager's response did not include the surface water monitoring. And so that's my objection. I would urge the board to include surface water monitoring. And as I recall, the narrative portion of the general manager's response did not have an objection to including surface water monitoring. It just, that language just was left out of the draft permit that they attached.
Okay. Thank you.
Other questions? Thank you, Ms. Prowse.
Thank you.
Are there any other parties here that wish to speak before I bring up the general manager? I did. All right. I heard that. I'm not here. All right, Ms. Martin, speaking on behalf of the general manager, Jim Totten.
All right, good afternoon, President Smith and board directors. I'm Natasha Martin here on behalf of General Manager Jim Totten. As you know, I'll do two things. I'll walk through the GM's recommended changes to the permit that was issued last November, and I'll also address a couple of things that have come up today. And then I'll be here for questions. So first, I'm just not happy with this microphone. It's not built for short people. Okay, so let me talk about an issue that's come up with the APA. I've reviewed both the APA in Chapter 36 and how it treats a GCD board's response to a PFD, and in particular, response to exceptions submitted on the PFD. I find nothing that requires a written demonstration for why certain things were changed in the PFD. However, as we indicated in our brief, we do encourage that you set out what portions of 36.4165 in Chapter 36 you relied upon in making the changes. However, we do not see anywhere that it is required that you have to do that. And in fact, it appears that LCRA's understanding of that supposed requirement comes from actually a TCQ rule where they do require that upon request of a party. So having addressed that, we'll take a look at the permit that the GM filed with the board and is also served on the parties. That permit makes two notable changes, and we'll talk about those changes. So this is an attachment A to the GM's brief. You can walk and look through those changes with me. We struck special condition 1 as no longer necessary. That condition allows for a monitoring well agreement to monitor both groundwater and surface water. However, it did allow for negotiation between LCRA and the district on what that monitoring would look like. This condition was included when the permit was in the form of walking through phases. The production would increase through phases. without phases, there'd be no reason to gather the data from the monitoring in order to implement the formula, which was struck from the permit. Although we don't think it necessary, that doesn't mean that the board doesn't have the authority to impose monitoring requirements. District Rule 5.2D reads that the operating permit may include special conditions requiring the permittee to drill and complete monitoring wells or provide other monitoring equipment to be conveyed to the district. Such a special condition shall require no more than one monitoring well for every 5,000 acre feet of water authorized to be withdrawn under the operating permit. So in order to be consistent with other permits issued by the district, the GM did recommend that that monitoring well requirement come out. However, the board has authority to impose monitoring should it see fit. Another thing we wanted to address, there have been claims by LCRA that they've been treated unfairly, and that is not the case. First, I think primarily would be discussion of the cutback from 25,000 acre feet to 8,000 acre feet for the production rate. It is true in the GM's brief, the GM did not heavily weigh in on that issue, but I will remind the board that it was the GM's expert that said it was difficult to predict impacts to surface water and also impacts to existing users on a long-term basis using the GAM model. And so, you know, the board can rely on the evidence, but it's also true that LCRA was not cut back for any reason that they've been, you know, unfairly compared to recharge or let's say gatehouse. As you just discussed, the board has factors under Chapter 36 it must consider, and the board considered those factors and thereby made that reduction in the permit, and it was authorized to do so. I'm here and available to answer questions.
Board members, do you have questions? Mr. Ellis?
Thank you, Natasha. That was condition one included both groundwater monitoring and surface water monitoring?
It would have allowed for the negotiation to impose surface water and groundwater monitoring.
Okay. Do you, since you're suggesting we remove that, although the district can require now one monitoring well for every 5,000 acre feet on the permit, that'd be one monitoring well for an 8,000 acre foot permit, be 5 for a 25,000 acre foot permit. But there's no such standard for surface water in the rules, surface water monitoring.
If you want to read that line in 5.2 D2 to allow for other monitoring equipment to support surface water, I mean, that is, you know, I think up to the board, but I would suggest that would probably be the only reference that would allow for it.
Okay. Have you received any comments from the other parties about your proposed permit or talked to LCRA about your proposed changes to the permit?
No.
Okay, so this is not an agreed to permit at this point.
Well, I wouldn't say that it's agreed to, but we also didn't pull any objections to it after we filed it.
Okay. Thank you.
Okay.
Thank you, Ms. Martin. Miss Emily Rogers.
Thank you. I'd like to take the opportunity to address some of the points that were raised by some of the parties. First, you know that saying, if you say it enough, people will start to think it's true. I think that is what Recharge, the Brown landowners and others are hoping are going to happen here. However, their arguments don't withstand the scrutiny when you read the PFD and the evidence in this case. Also, when someone says the evidence is uncontroverted, that simply isn't true. The ALJs considered these arguments and rejected them, and they weren't interested in conspiracy theories. As shown on attachment 2 to LCRA's latest brief, LCRA evaluated the impacts of pumping on Recharge, Aqua, Elgin, and the other testing parties in this case using site-specific geological data, well log information, the GAM, and other information. The parties had an opportunity to present their own evidence on these issues, and after the ALJs heard all of the evidence, they determined LCRA's witnesses were more credible and the evidence was more reliable. And thus they determined LCRA's proposed pumping of 25,000 acre feet per year of water would not unreasonably affect groundwater users, and the permit conditions would lessen well interference. The LJs did not have to cite to every piece of evidence that was presented. Moving on to this issue about phasing. First of all, I want to make it clear, simply settling a case doesn't make a difference of whether or not a provision can be required. You either have the authority to do it or you don't. You can't settle with someone and include a permit condition that the board doesn't have the authority to impose. Section 36.113 provides the board with the authority to regulate production. Phasing is nothing more than regulating production. Phasing is a permissible condition, and it doesn't run afoul of a person's opportunity to get notice or to have a hearing. All the parties in this case received notice of LCRA's permits and there was a hearing on the entire 25,000 acre feet of water. When LCRA moves to a new phase under the permit, this isn't an amendment to the permit. LCRA would already be authorized for the full 25,000 acre feet, subject to meeting conditions. Reviewing the monitoring data submitted to the GM, and that evaluation process is merely a demonstration of compliance with the terms and conditions of the permit to be able to move to the next phase. If the GM decides those conditions aren't met, LCRA gets to challenge that, just like a permittee would be allowed to do in an enforcement case. Also, just so y'all know, phasing production has been approved legally authorized by SOA ALJs. In the matter of the groundwater production applications of electropurification filed in the Barton Springs Edward Aquifer Conservation District case, and that was contested at SOA, the SOA judges considered the exact same argument that is now before, oops, I lost my pages, that is now before you. The protestants moved for summary judgment on the basis that a phased permit was not legally authorized and the amendment process should be followed instead. The SOA judge ruled phasing to be a valid approach to permitting the amount of production. As here, the ALJ said phases are special conditions contained in the permit, not amendments to the permit. And the protestants in that case, like the ones in this case, had the opportunity to prove that the full amount requested should not be authorized. And I can provide you, that's order number 11 and SOA docket number 957-18-4985. That was issued on January 2020. That case has been remanded back to the electropurification asked that their application be remanded back to the district. With respect to the argument about surface water monitoring, let's be clear that the ALJs found that LCRA's pumping alone will not have an unreasonable effect on surface water. The ALJ's findings were based on the cumulative impacts of all pumping at some point in the future. And this board can decide and should decide not to adopt unconstitutional requirements. Environmental stewardship would have LCRA bear the sole burden of monitoring the impacts of all permittees on surface water. Also, environmental stewardship is suggesting a new standard. This board should only has to consider whether there are unreasonable impacts, not that there are no impacts. Finally, I want to remind you, section 36.4165 doesn't specifically say the reasons for change, that the reasons for the changes have to be in writing. But the courts are clear that the board must provide the parties its reasons for making the changes to the findings and conclusions in some form to enhance the fairness of the adjudicative process for the parties appearing before this district and to ensure that a reviewing court can judge whether the district has followed the procedures set out in section 36.4165 and the district rules and statutes. With that, I don't have any further comments. Oh, I do want to address one more thing about the groundwater monitoring. I will point out that the rules that are in place for LCRA don't specifically require or have that provision, the 5,000 acre feet groundwater monitoring requirement. And I want to point out that when you issue a permit for 8,000 acre feet, you're going to be asking LCRA to do monitoring that you haven't required of other permittees. With that, I'll answer any other questions.
Board members, do you have questions? Mr. Ellis?
I'm guessing the only thing in the GM's proposed permit that they put attached to the brief would be the total amount of pumping allowed.
Yes, we're asking for the 25,000 acre feet.
But you're
With
okay with
phases.
the other changes being recommended there?
I'd have to go back and look. I mean, we had a permit that came out of the proceeding, with the exception of the surface water monitoring. The permits that came out after the hearing are the permits that LCRA would want, with the exception of the surface water monitoring.
Under the phased in approach, it was, if I remember correctly, it was 8,000, 15,000, 25,000.
I believe that's correct.
How fast can LCRA get to that 15,000 number under the proposed permit from the ALJ?
I believe the first phase is just having the contracts, which we
Right.
already have. So we're already past phase one. So phase two, you would have to be using up to 5,000, or I'm sorry, 8,000 acre feet for a period of 3 years consecutively. And then it goes to 15 and you have to use the 15 or up to 15. Obviously, it's hard to use exactly 15 for a period of 3 consecutive years. And then you can move to the final phase after you've done that for the 25.
So absolute minimum 6 years before you get to the 25,000 acre foot number.
That's probably correct. Yes.
Okay. And does a record at all say anything about how quickly you actually think you're going to be able to get the pipelines built in the water moved?
No, we don't have anything in the record about building pipelines. I mean, you obviously would want your permit in place before you start building pipelines.
Right. But I was curious how long you think it'll take to start moving the water to where you can sell it. where you
I
need
don't
it.
know the answer to that.
And well, whether you know the answer or not, it's not in the record anywhere, right?
It's not in the record. We did not put that in the record.
Okay. So I guess you disagree with my characterization that the phased in approach kind of bypasses the amendment process?
I do. I disagree with that. Because again, it is a permit condition about the production authorization, and it's the timing of the production. And it is a special condition that we have to meet. It's either an up or down. And if we don't agree because maybe we think the monitoring well data was skewed or something like that, that's when we go and we say, GM, we complied. You're saying we didn't. We protest that. But otherwise, it is input into a formula and it spits out an answer.
Well, if our other permits get challenged in court, we'll be calling on you to help us with that argument.
Well, I think they would be surprised to find out that this board thinks that the permits they issued were illegal.
Well, there's illegal and there's illegal. I mean, like I said, if we had reached a settlement in this case, everybody that could file an appeal of this decision would have settled already. So it's not good. They're good.
Somehow it's now miraculously okay, but you can't have vision in a permit. So only thing this.
For some reason, the microphone went off, I think. Mine's.
I'm sorry about it. Let's say we all settled and we decided that LCRA, or we decided that a permit, we'll use a fictitious permit here, that the permit that you were issued in a contested case, we decided to settle, and we just said, well, we're not going to allow you to sell the water to women. That's an illegal provision. You can't settle for that. So either you have the authority to do it or you don't. And simply settling doesn't make it okay.
I realize I'm a very old school lawyer. I've been doing this a very long time. And maybe the law schools have changed what they teach. They teach you to think like a lawyer, right? And one of the tenets I heard was you can do anything you don't get sued for.
Well, that's really probably, I'm not sure I think that that's a great approach.
Not a great attitude. I understand. But I'm a whole lot more worried about things we can get sued for by people who have standing to sue us than I am about things people don't have standing to sue us over.
Well, I think
So-
somebody might have standing to sue if you did include a provision that is not legal. You will have other groundwater owners here that would say,
And again, if that person shows up and files that lawsuit, then I'll be glad to quote you on our strong ability to have those type of phased-in approaches. Because again, and I've got the same issue with the surface water monitoring. Our rules just don't address it. Our rules don't address surface water monitoring. Our rules don't address phased-in conditions. And we've had a number of years to put those in the rules, and it hasn't happened. So, I don't know that these are very difficult decisions for everybody around. And I appreciate y'all's patience in getting to this point, and we'll see what the board does with it.
okay, thank you.
May I ask you a question?
Sure.
When you receive this water, groundwater, are you planning on shutting off surface water usage?
No,
So you're going to continue to pump the same amount of surface water and add this to your,
it goes
Usage?
into the portfolio of water resources that LCRA has.
please forgive me, but
Oh, I'm
talk
sorry, I
a little
apologize.
slower and
I apologize.
do it again. Go
Sorry.
ahead.
It will go into LCRA's water portfolio, so to speak. They need all the water. There's a 50-year plan out there that, we're looking long-term planning horizons for meeting the water supply needs in this region. And so it's just another source. In addition, it would help be a drought. It would help drought proof some of LCRA's current supplies. So if the surface water isn't available, it could use this groundwater to supply some of its customers.
So then when Father Time and Mother Nature decides to let water flow again, you're going to stop the groundwater usage and go back to your normal everyday.
Well, again, I'll go back and say it's part of the whole portfolio of water that LCRA has. And I can't speak to exactly how they would manage the different resources at different times of the year or in different ways.
Thank you, ma'am.
Thank you.
Thank you very much,
Thank
Ms.
you.
Rogers. Okay, excuse me, this concludes the rehearing. We will go to item number 5. Consideration of and possible action on the rehearing on the district's decision on the applications of Lower Colorado River Authority for operating permits and transfer permits for 8 wells in Bastrop County, SOA docket number 952-19-0705. And at this time, I believe the board wishes to adjourn into executive session. Okay. The board may recess into executive session to consult with its attorneys regarding any posted matter in which the board may seek the advice of its attorneys under Government Code 551.071, or for any action on the agenda for which a closed session is permitted by law, and we will reconvene an open session after executive session. So we now adjourn to executive session at 3:26 p.m. on April 4th. At 4. We are now back in the meeting at 4:15 PM on April the 4th. The board went into executive session. No votes were taken. Would anyone care to make a motion? I'd be happy to entertain one.
I would make a motion to approve the general manager's permit as presented.
There's a motion been made by Director Cole to approve the general manager's permit recommendations. Is there a second?
Second.
Mr. Arcidi, second.
I would like to make a subsequent motion to sever the questions and vote on each of the general manager's conditions separately. Mr. Ellis, could you read those for us? Oh, sorry.
Okay, so Ms. Cole has also suggested that we sever the question to vote on the general manager's recommendation in his report so that we can vote on them separately. Is there a second?
Second.
So we have a motion and a second to sever the question. All in favor?
Aye.
Aye.
Any opposed? Motion carries. Mr. Ellis, would you be so kind as to read the different questions?
The first change proposed by the general manager, and this permit would be to strike in its entirety condition 1. Condition 1 is the condition that requires the LCRA to enter into a monitoring well agreement. That monitoring well agreement would consist of new monitoring wells under the rules based on an 8,000 acre foot.
Recording in progress.
Unless that change, there will be a. We're getting an echo. I'm not. Under the rules, an 8,000 acre permit require 1 monitoring well. The second part of condition 1 is that the monitoring well agreement entered into shall include wells, gauges, or any scientifically supported tool to monitor surface water. So both, this condition includes both groundwater monitoring and surface water monitoring. So the question is there a motion to retain condition 1? Or parts of condition 1?
I move to retain condition 1.
Mr. Arsufi has moved that we retain condition 1 of the general manager's report.
And can I make a comment associated with that motion?
Yes.
Yeah, I think, with the water's not a limited resource. And it's going away. And we're getting a lot of population demands on our water in this particular region. So I think if we're going to look out for the next generation and for this generation, we need to be monitoring wells, groundwater, surface water, so that we can make informed decisions as conditions change.
Thank you, Mr. Arsufi. So we have a motion. Is there a second?
Second.
We have a motion and a second to retain condition number 1 to do with the surface water and groundwater monitoring. I'll do a record vote, roll call vote. Mr. Arsufi,
Yes.
Melissa Cole,
Yes.
Herb Cook,
Yes.
Billy Sherrill,
Yes.
Larry Shoddy,
Yes.
Mike Samang,
No.
and Cheryl Smith, myself, a yes. Motion passes.
The second change recommended by the general manager is to remove in its entirety condition 3. If you want to keep that condition, the condition 3 is the one that would require them to do certain reporting to the general manager prior to renewing their permit. If you want to keep that condition or any part of it, we need a motion to do so.
Just to be clear, he's recommending that be removed. Okay. I would entertain a motion. Would anyone care to make a motion?
I move that
No,
that be removed.
I'm sorry.
I move that condition be removed.
The original motion would already remove that because the motion was to accept the general manager's recommended changes. So if there's no motion, then that section will be stricken. All right, the third thing is we had a lot of discussion tonight about providing a detailed response of some kind. If we're going to provide a response of justification for change to the proposal for decision, my strong recommendation is that we do that in writing. Although I don't think it's required, I think it's a good idea. So the question is there a motion to prepare written justification for the changes to the PFD?
I would make a motion for written response for justification of the changes in the PFD.
Second.
Okay, we have a motion and a second for written justifications of the PFDs.
Second.
Oh, we have okay, now we have a third. Okay, roll call vote. Tom Arsufi,
Yes.
Melissa Cole,
Yes.
Herb Cook,
Yes.
Billy Sherrill,
No.
Larry Shoddy,
Yes.
Mike Samang,
Yes.
and Cheryl Smith. Yes. Motion passes.
Okay, based on that motion passing, again, my recommendation would be that we table this to the next board meeting so we have time to prepare those written responses and the board has time to review them and agree that those are their justifications for the action they've taken. So at this time, I think it'd be appropriate to move to table this item to the next board meeting.
We entertain a motion to table. Mike Samang motions to table. Second, Mr. Shoddy. All in favor?
Aye.
Any opposed? Motion carries. This concludes the board action for the evening. We stand adjourned as of 4:22 p.m. April the 4th. Thank you all for attending.